This case is a perfect example of a courtroom balancing act between punishment and redemption. A man with multiple drunk driving convictions stands before the judge after pleading guilty to yet another DWI offense. The prosecution says enough is enough and pushes for the maximum sentence, while the defense argues that this time is different, that treatment, sobriety, and genuine remorse have changed the defendant's path. But with a fifth DWI conviction and a crash already on his record, the question becomes how many chances should someone get before the system draws a hard line? Stay tuned, because the judge is about to make a decision that could change this defendant's life forever.
All right, sir, are you Dustin Drake?
Yes, ma'am.
And Mr. Drake was previously in court. You entered a plea of guilty to driving while intoxicated, third or more. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, and we have no objection.
Yes, Your Honor, we reviewed it.
And there was no agreement. Mr. Lane, you may proceed.
Thank you, Your Honor. I guess in situations like this, the PSI pretty much laid it out. So I don't know if Mr. Drake can be any more sincere than he was. I think the PSI officer got that from him. Most of his allegations were DWIs. After this allegation, we know he entered treatment. He went through almost 18 months worth of treatment. He stayed sober. He's gainfully employed. He's moving forward. He knows that the court has a tough decision. I think he said it best in the recommendation where he was. I think he can be successful. His attitudes.
At this point, the prosecution is focusing on one issue above all else: public safety. Notice how the argument isn't centered on whether the defendant has made progress recently. Instead, it's about the risk of putting someone with multiple alcohol-related driving convictions back on the road. That's a powerful argument in any courtroom, because judges have to consider not only the person standing before them, but also the potential consequences for everyone else in the community. The prosecutor is essentially saying that while treatment and rehabilitation are admirable, the pattern of behavior speaks louder than promises. What do you think? Should a long history of repeat offenses outweigh recent efforts to turn things around? Or should courts give more weight to genuine rehabilitation?
His groundwork is there, his mother's here, the foundation is all there to be successful.
Mr. Nichols?
Judge, this is his fifth DWI conviction, not counting two that were dismissed somewhere along the way. I left, when we formulated this plea offer, I left it as a count one plea to limit some exposure, but I think the pen time is where we're at. I get, and I'm glad that there's what appears to be sincere attempts at getting treatment and doing all that, but the fact is, he hit a car, and this night he was 0.27.
This is where the hearing takes an interesting turn. The judge isn't ignoring the defendant's history, but he's also looking for factors that might justify a different outcome. One detail that stands out is the lack of meaningful probation supervision in the past. Instead of simply asking whether the defendant has failed before, the judge is examining whether he's ever truly been given the structure and accountability that probation can provide. Courts often look for opportunities to reduce future risk, rather than simply impose punishment. However, make no mistake, this is still a high-stakes moment. The judge is weighing years of bad decisions against evidence of recent change, and the next few minutes will reveal whether mercy or maximum punishment wins out.
Luckily, no one else was hurt. And I just can't fathom letting him back out on the road, Judge. So I would urge the court to exercise the full 10 years.
Mr. Drake, other than what's in the PSI that you stated, do you have anything else to add?
No, I really apologize for what I did. I know it was wrong. I am an alcoholic, and I do believe I can finish the probation. I'm not going to sit here and make excuses for my actions because there are none. My record speaks for itself. I'm embarrassed and ashamed.
And I appreciate that, and I appreciate you not trying to make excuses. And I appreciate that you've gotten treatment. The time for treatment was before your fifth DWI.
I agree.
You know, you've had every opportunity since, it looks like, 05, 19, 2021, well, 09, then 10. I guess part of what I'm looking at right now is that there was a short probation from Louisiana some years back, 6 months. But other than that, there's never been, you've just gotten time, correct?
Yes, ma'am.
Okay, here's what I'm gonna do, Mr. Drake, and I hope you take advantage of what I'm about to do. Just based on several of the factors, the age of some of the history, the fact that you've gone into treatment already, I'm going to give you an opportunity, but you're not going home today. So here's what's going to happen. I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty. Sentence you to a term of 10 years in prison, but I'm going to probate that. You'll be on probation for 10 years. I'm ordering that you pay a $2,000 fine, and I'm ordering that you follow all of the rules and conditions of probation. The first one of those conditions is that you're going to enter and successfully complete the SafeP program. It's a 6-month in-custody program. It's the longest.
In the end, the judge delivered a sentence that combines both accountability and opportunity. The defendant received a 10-year prison sentence, but that sentence was probated, meaning he has a chance to remain out of prison if he strictly follows every condition imposed by the court. Those conditions include an intensive in-custody treatment program, ongoing outpatient treatment, alcohol monitoring, an ignition interlock device, and strict probation supervision. The judge made one thing crystal clear. Any violation could immediately trigger the full 10-year prison sentence. This ruling reflects a common challenge in the justice system, protecting the public while still allowing room for rehabilitation when a defendant shows signs of genuine change. The court has offered one final opportunity, but it comes with zero margin for error. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
And best we have, and so at least that gives me some knowledge that you have some further treatment and some long-term treatment. When you're released, you will go through the JCDI program as your outpatient follow-up care, which is an intensive outpatient treatment. You will be required to have an auto ignition interlock device on any vehicle that you drive. I'm also going to order, at least for some amount of time, at the, I don't know how long, but you will be ordered to wear a scram device as well. That is a device that is on your body that shows if there's any alcohol in your body. If there is a positive sip of alcohol, your probation is going to be revoked and you're going to be facing that 10 years that I just gave you. So I didn't give you up to 10 years. I just gave you 10 years in prison. If you violate this probation, don't come in and start negotiation for something less. It's 10 years. Do you understand? So you'll have the scram, the auto ignition, SafeP, JCDI, and any other conditions that probation deems would be important for you to be successful. So this wasn't an agreement. You do have some rights to appeal. I'm handing you the trial court certification. Well, it shows that y'all waived the right to appeal on this. So
That's because we did have an agreement.
you did have an
to go on
agreement.
Count one, Your Honor.
Correct. So you have waived your right to appeal because the state made that concession that they went forward on count one only. I've also handed you the trial court certification or admonishment that shows that that because of the judgment entered against you, you're ineligible to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lane. As it also, obviously you're going into custody, but I am ordering as a condition of that probation, it's mandatory 10 days upfront time. So you'll get that credit while you're waiting on safety. All right, you can go back with the bailiff.
Okay, can I speak from,
I'll go.
run
Yeah,
poll time?
no, go with the bailiff.
Thank you, Your Honor.
Yes, sir. Mr. Burbank, you have